It's Monday, and that means another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're going skydiving. Cases that should have gone to the Supreme Court of Canada, but didn't. Well, we're not going skydiving because we don't have a federal permit, which is the issue that arose for Mr. Leclerc, who sought from the city of Levis permission to build a skydiving facility. He was denied the opportunity to build the skydiving facility on the basis of the fact that the municipality thought that this was ultimately an issue of federal jurisdiction and that they weren't permitted to give him a permit for a skydiving facility. The reason for this is that in Canada, anything related to aviation and aeronautics is a matter of federal jurisdiction, which means the permit needed to come from the federal government. But never before had a case considered whether or not skydiving itself was a matter of federal jurisdiction, whether it was part of aviation or aeronautics, or whether it was just a fun activity that some people like to do who have a lot more bravery than me. This was an opportunity for the Supreme Court of Canada to address whether skydiving itself falls within federal or provincial jurisdiction. This is an important issue because as people become more adventuresome, as thrill-seeking becomes more popular, issues like skydiving, base jumping, things like that, jumping off tall buildings, all becomes questionably matters of federal jurisdiction that can't be regulated by provinces. And those things need to be then regulated by the feds. What the government regulates and who regulates it is exactly the type of thing that the Supreme Court of Canada should determine, particularly where somebody like Mr. Leclerc is trying to establish a business and needs to go through a process which requires permits, approval, renting spaces, and significant financial outlay without really knowing which law, federal or municipal or provincial, applies to the activity that he's seeking to undertake to do. In the circumstances, the Supreme Court of Canada could have looked at new classes of behavior that takes place in the sky and determined whether or not it was something that falls within federal jurisdiction or whether it's not. This was an opportunity for the Supreme Court of Canada to clarify the way that aviation and aeronautics has expanded or perhaps not expanded to include these opportunities and these activities. And they missed a chance here to look at a broader application of the living tree that is our Constitution. The Supreme Court of Canada missed an opportunity in this case, and in my view, it was an important case that could have clarified how the Constitution has grown and whether or not it's appropriate really to consider things like skydiving as a matter of federal jurisdiction. Unfortunately, it's going to take another case and another person jumping somewhere in the sky for the Supreme Court of Canada to hear this. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting these videos together, and like, subscribe, and share with your friends.